ahead and start introducing myself in case a couple more people come in, and if not, then we're going to have quite an intimate discussion. So my name is Marissa Webb, and I'm the housing investigator for the Lexington Human Rights Commission. So I conduct all the housing investigations. Of course, my job duties don't just end there. They also extend to during presentations, as I'm doing now, compliance review, which just means that after an investigation finishes, ensuring that the respondent has done what they're supposed to do if there was a conciliation agreement that was reached. But I also do employment investigations and public accommodations investigations as well. Now, today we're going to be talking about fair housing and domestic violence. I'll go ahead and pull up my presentation, start sharing that with you all. Perfect. And go ahead and start the slideshow. And if you have any questions or concerns or just things that you maybe want greater clarification on, I encourage you to speak out during the presentation. Those of you who have had a presentation with me before, you know that I really like exchanging dialogue. I really like conversation. Sometimes I've even added in some, oh, it sounds like somebody's music is on. Or maybe a phone? Okay. So I do encourage conversation. I do encourage discussion. And I really try, especially if I pose a scenario or if we're talking about an example, I really try to encourage all individuals to speak up. You shouldn't be afraid of saying the wrong thing, because what we're here to do today is to learn, to go through it together, and hopefully come out with greater clarity. Does anybody have any questions before we get started?
Nope.
And I see here, because some individuals have their screens turned off, which is fine. If you do have multiple individuals, Assurance, I think I know who's all there, but if there are multiple individuals with you, please feel free. I sent you an email earlier today with the PowerPoint and a couple of the documents that we're going to be talking about. Feel free to reply to that email, send me an email telling me that if multiple individuals were with you. That way I can mark them as there. All right, well, we'll go ahead and get started. So the Fair Housing Act, you all know that I love talking about what you know. So if you could go ahead and just shout some things out. What do you know about the Fair Housing Act? Sorry about that. Anything at all.
It's designed to make sure everybody has an equal shot of getting the same type of housing.
Yes, that's exactly right. Any other, anything else we know about the Fair Housing Act? Some protected classes, maybe?
Gender, race, national origin.
Mm-hmm.
Sexual orientation.
Yeah. Well,
Who's that?
yeah, sexual orientation, familial status.
Excellent. Now, oh, sorry, y'all. So, 1968, the Fair Housing Act was passed. For our purposes today, what we'll be talking about, 1974 is when sex was added as a protected class. So it was not added when the act was originally passed. It had to be amended. What we'll be talking about today as well is kind of our broad overview, that way you know. We're going to also be talking about a couple of HUD memos. The most recent one is that 2016 HUD memo that I have listed here, as well as the one that and I did send it with you with that email. The application of the Fair Housing Act standards to the enforcement concerning local nuisances, crime-free housing ordinances, and how that affects victims of domestic violence. And then we're also going to be talking about a couple of state statutes. So KRS 383.300 to 302. And those are the two that we're going to be talking about today. Now, is domestic violence a protected class under the Fair Housing Act?
Yes, I think so.
Okay, we have a yes. Opposite,
Yes.
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 I didn't know. I should. I'm for it.
So domestic violence, it is covered under the Fair Housing Act, but it's not a protected class.
Yeah.
However, sex is a protected class under the Fair Housing Act. Now we'll talk about a couple statistics. Obviously, it's domestic violence can happen for individuals of either sex here in Lexington, in other municipalities in Kentucky. It can also, if sexual orientation, gender identity is also protected, then it doesn't have to fall into sex. It can be, an individual who is non-binary can also bring forth a complaint of discrimination based off of domestic violence. So first thing we're going to do is talk about domestic violence. So 1 in 3 women, 1 in 4 men have experienced some form of physical violence by an intimate partner. This can be a range of shoving, slapping, etc. And that number actually will decrease concerning severe physical violence. So 1 in 4 women and 1 in 7 men have been victims of severe physical violence. This includes beating, burning, strangling by an intimate partner in their lifetime. So it does happen more frequently with women than men, but both can and do experience this. And the rate of being a victim of domestic violence actually increases when you have these other identities as well. So African American women and Native American women experience higher rates of domestic violence than white women. So for Black women, they experience domestic violence, partner violence at a rate that's 35% higher than white women. Native American women are victims of violent crime at a rate that's more than double than other racial groups. So even though being domestic violence, being a victim of domestic violence is not protected class under the Fair Housing Act, because you are statistically more likely to become a victim of domestic violence because of these certain identities and categories, not because of, but they correlate, then you can actually bring forth a complaint of domestic violence based upon your sex, based upon your race, based upon your ethnicity. So domestic violence really is in a Venn diagram of identities, and you can bring forth a complaint based off of those various identities. So that's nationally. Now let's talk about it here in Kentucky, because I always want to start broad and narrow in scope. So 45.3% of Kentucky women and 35.5% of Kentucky men experience partner physical violence. This includes rape in their lifetime. So almost half of Kentucky women and over a third of Kentucky men. So it is happening, and that's why this is so important to talk about and to be aware of what these individuals, what their protections are under the Fair Housing Act. So Kentucky has the 11th highest rate of femicide in the United States. Just means killing women. So violence, typically domestic violence situations, it does escalate to that point, which is why some of these HUD amendments that we'll go through and HUD memos that we'll go through have become have been issued. So in any given day, one day in 2019, Kentucky domestic violence programs served over 1,000 adult and child survivors, and then another 128 requests just went unanswered. This could be because of just the lack of resources. Kentucky has a lot of counties, so not every county may have a center that they can go to or that they feel comfortable calling, etc. And as of December 31st, 2019, so almost 1 year ago, Kentucky submitted 743 domestic violence misdemeanors into the criminal database index. So certainly a lot is happening here, which is why that this is so important to talk about and discuss. The first memo that we have, and as I said, we're going to be going from least recent to most recent when discussing this. This first one is actually from Sarah K. Pratt, who I believe used to live in Kentucky, and she was the Assistant Secretary for Enforcement Programs. That is what we do. So you get a letter from us here at the Commission. We're an enforcement program. So we enforce the Fair Housing Act. And this memo was concerning claims of housing discrimination against victims of domestic violence and the Violence Against Women Act. So, and in the memo starting, she briefly talked about the purpose, why she felt the need, why the U.S. Department of Housing and Urban Development had to issue this memo. And they indicated survivors of domestic violence often face housing discrimination because of their history or the acts of their abusers. Housing authorities and landlords evict victims under zero tolerance crime policies, citing the violence of a household member, guest, or other person under the victim's control. Victims are often evicted after repeated calls to the police for domestic violence incidents because of allegations of disturbances to other tenants. Victims are also evicted because of property damage caused by their abusers. In many cases, adverse housing action punishes the victims for the violence inflicted upon them. This double victimization is unfair and may be illegal. So first we'll talk about this one strike rule. But hopefully, well, we'll go ahead and talk about it first before I start asking you all some questions. So this is actually concerning 2001. HUD's issued that one strike rule that authorized landlords, housing authorities to evict tenants for criminal activity committed by any household member or guest. This rule allows owners of public and Section 8 housing to terminate a tenant's lease because of criminal activity by the tenant, a guest, individual, or what is often seen, a tenant, an individual under the tenant's control that threatens the health, safety, or right to peaceful enjoyment. And this is often where a victim of domestic violence, where if it's their abuser that is committing these actions, they can be seen as the tenant's guest or individual under the tenant's control. Okay, so first let's talk about the Violence Against Women Act. I know that some Housing organizations, you will have a clause that includes that act in your lease, in your as an amendment, maybe even. Does anybody know a little bit about that? And if not, you can say, I'm not quite sure. We may have it in the lease. I don't know if we have it in the lease. Anything you can think of. Okay. Well, then we will talk about it a little bit. Now you can know a little bit more about it. So the Violence Against Women Act prohibits evictions in public housing, voucher, or Section 8 based programs. So if you're a private housing, I'm a landlord, I only have 15 units and I don't take Section 8. Am I covered under the Violence Against Women Act? What do we think? Yes, maybe no?
Is it private or public housing?
Private. So I just have 15 units. I bought a small building. I'm renting it out. Just me, I don't take Section 8.
No.
I think it is.
Exactly. So the Violence Against Women Act does not apply to me. However, let's say if I did take Section 8 housing, it does apply to me. Now, you may have heard a couple of years ago, and sorry, as an aside, the Violence Against Women Act protects victims of domestic violence, dating violence, sexual assault. It actually is a little bit broader of a definition than just domestic violence. So the Violence Against Women Act lapsed because of Congress's failure to reauthorize it in 2018. Now, does the Violence Against Women Act still apply to me? Yes or no?
I say yes.
Yes. Because the housing protections do not have a sunset provision, they don't expire. So even though other aspects of the Violence Against Women Act did expire in 2018, an individual, if you're public housing, if you take Section 8 housing vouchers, and they come to you and they say, I am protected by the Violence Against Women's Act, and you're thinking, well, I know I heard on the news it actually lapsed, so I don't think so. Housing protections do not have a sunset provision. They're not expired. So that's concerning just public housing, and public housing, housing vouchers, Section 8. I'm not sure how many of you all that applies to, but we will be talking about, well, what if I'm a private? I'm that landlord. I just have that small building, 15 units. I don't take Section 8. What about me? And we will talk about you. So next, we'll actually talk about a case. Now this case is a little old, but I thought that it was very similar to several cases that we've seen even more recently. So the victim was assaulted by her husband in their apartment. She obtained a restraining order against the husband, and he was arrested and jailed for the assault. She provided a copy of the restraining order to the property manager. The property manager then served a 24-hour eviction notice based off of the incident of domestic violence. The notice specified, you, someone in your control, or your pet has seriously threatened to immediately inflict personal injury or has inflicted personal injury upon the landlord or tenants. The victim then submitted an application for a one-bedroom apartment in the same building. Management denied the application and refused to accept her rent. After a second application, management finally approved her for a one-bedroom apartment, but warned her that any type of reoccurrence, this is that one strike rule, any type of reoccurrence of domestic violence could and would lead to her eviction. The victim filed a complaint with HUD, which investigated her case, issued a charge of discrimination against the apartment management group. She elected to pursue the case in federal court. The parties later agreed to settle, and there was a consent decree that was actually approved by the Oregon District Court in 2001, which requires that the management group agree not to evict, otherwise discriminate against tenants because they've been victims of domestic violence or victims of violence, including domestic violence, and change its policies accordingly. They had to participate in education about discrimination and fair housing law, and they agreed to pay compensatory damages to the victim. So we have a couple of things that are happening here and a couple of things that we're actually going to talk about. Well, this was 2001. This was in Oregon. What about me in Kentucky? Before we get to that, we're going to talk about our latest guidance from HUD. This is the 2016 General Counsel guidance concerning the enforcement of local nuisance, crime-free housing ordinances against victims of domestic violence and other crimes, or those who engage or require police or emergency services. Now, can anybody tell me, or you don't have to tell me, just I want you to think, does my lease have a crime-free provision in it? Does it have some kind of nuisance ordinance in there? My municipality, we'll talk about Lexington, but does my municipality, is there a local noise ordinance or nuisance ordinance where I'm at? And is that in my lease? So start thinking about those kinds of things. So this guidance primarily focuses on the impact that these ordinances have. It details the standards described within the ordinance or within the guidance that apply equally to victims of domestic violence and other crimes and to those who may be in need of emergency services. And who may be subjected to discrimination prohibited by the act because of these services. If I have a crime-free ordinance in my lease agreement, what can potentially happen, and the way that we would investigate these kinds of cases is it's called disparate impact. And it means that even though we have a neutral policy, it may affect certain members of a protected class differently. For example, we'll talk about we don't allow any felonies. If you have a felony, you cannot rent from us. Or if you have any crime on your record, you cannot rent from us. Well, that may actually have an adverse impact on Black and Brown Americans, Black and Brown individuals, because of the incarceration rates of that is disproportionately higher for Black and Brown individuals. So in this case, in this example, you would have to determine, is what I'm asking for reasonable? Is it a reasonable standard? Am I asking for, am I evicting people or denying people to rent from me because of something on their criminal record that happened 20 years ago that was nonviolent, or something that was more recent? So you have to think about those things. Does this neutral seeming policy have this adverse impact? And what HUD ruled, that these crime-free ordinances, these nuisance ordinances, they could have an impact on victims of domestic violence. Based off of this example, can anybody kind of guess as to how that is, why that would be? Again, there's no wrong answer. I encourage you to speak up. Tell me what you think, or if you say, I'm not sure, that's okay too. I hear some whispers, but I'm not sure if they're for me. So I'll go ahead and, oh. Did I hear something? No? Okay. Well then, So again, these guidances details how noise ordinances often label conduct associated with a property, whether the conduct is by a resident guest or another person, a nuisance, and requires the landlord to abate the nuisance at the risk of penalties. So if you have something along the lines of, I have a noise or nuisance ordinance, crime-free ordinance, this can adversely impact victims of domestic violence, because what could happen is if they're calling the police because their abuser broke in, well, if I called the police and I have a history of calling the police because of this domestic violence situation, this nuisance policy isn't taking account that I'm a victim of domestic violence. It's having this adverse impact on me and other individuals who would need to call the police for their safety. And nuisance could be quite broad. It could mean an excessive number of calls to emergency services. What does that excessive number of calls even look like? Is it more than one? Is it more than 4? Is it 10? These standards are quite loose, which is why HUD issued and provided this guidance. And as I said, these ordinances could be without regard to domestic violence victims. Now, Lexington has a noise disturbance generally and violations deemed a public nuisance. Let me go ahead and click on them, and I will share the screen. That way you all will be able to see it too. And here we go. So you should be able to see this one right here. So violations deemed a public nuisance is here. And I inserted the link in the presentation. I obviously sent it out. That way you can click on it as well. And just like, as I stated before, what nuisance means, what excessive means, these are really broad. And in fact, the violations deemed a public nuisance are also broad. A threat to public safety, public health, welfare, could be declared and deemed a public nuisance. And the other, for example, the other one, a noise disturbance. No person shall make or continue or cause to be made, continued or permitted noise disturbances on right of way or a public place. This section should not apply to non-commercial public speaking or assembly to gather. So this is currently what, oh, I see a question from Alice Justice. Is this assuming we are aware that the resident is a victim of domestic violence? I'm really glad that you asked this question, because we will talk about this. You as a landlord, you do have some rights. So if you know that it's a victim of domestic violence, how do I know that? How am I aware of this? And we will talk about that when we get into those actual Kentucky statutes. This is a broad overview indicating that if you do have, if you take this noise disturbance as defined by Lexington, Fayette County, and you include that in your lease agreement, that is indicating it could have this impact. I'm encouraging individuals, property managers, owners to rethink if you have these kinds of amendments, policies within your lease, to rethink, does this have an adverse impact? Does this have an impact on victims of domestic violence? Because I have this policy in place which states that I can evict you because of this. So here's an example. We'll talk about an example of it. A woman in Pennsylvania who had been subjected to domestic violence by her boyfriend was warned by police that if she made one more 911 call, and this is a very extreme example, so I will warn you, she and her young daughter would be evicted from their home pursuant to the local nuisance ordinance. The ordinance operated under a 3-strike policy, allowing her no more than 2 calls to 911 for help. As a result, she was too afraid to call the police when her ex-boyfriend returned to her home and inflicted harm and stabbed her. Rather than call for the ambulance, she ran out of the house in hopes that she would not lose her housing. A neighbor called the police, and due to the serious nature of her injury, she was airlifted to the hospital. A few days after she returned home from the hospital, she was served with eviction papers pursuant to the local nuisance ordinance. So this is a very, very much an extreme example of potentially how these nuisance ordinances, how these crime-free ordinances can actually adversely impact victims of domestic violence. So back to Alice's question, how are we supposed to know if this individual is a victim of domestic violence? And now we're going to talk about the Kentucky statutes. So we'll talk about KRS. This is the first one. It is on 383.300, and we'll talk about protected tenant and a named individual. So protected tenant is a tenant, applicant, or tenant with a minor child who is protected by an EPO, an emergency protective order, a temporary interpersonal order prohibiting contact, a domestic violence order, or an interpersonal protective order. You could also include a criminal pretrial release, no contact order. And what makes them a protected tenant is that they are protected by this court-issued document, but also that they provided the document to you. So, and we'll see here, there'll be a couple of slides about what you can do, what you can't do, what tenants' rights are, what a landlord's right is, and we'll talk about some of the provisions in that, specifically details that the tenant has to provide the landlord with a copy of these orders. Now, who's a named individual? A named individual is the person identified in the protective order. So EPO, IPO, TIPO, and DBO. Now, a named individual cannot also be a protected tenant. So if, say, mutual arrests were made, or both individuals have IPOs and EPOs against each other, that means that they are no longer a protected tenant. So a landlord cannot terminate, fail to renew, refuse to enter into, or otherwise retaliate in renting or leasing of a residence because of their status as a protected tenant. Now, here is where you probably care as landlords. So the court must determine, in order to say that, yes, you violated this law, the court must determine that, one, the tenant is in fact a protected tenant, and the notice to vacate is substantially based on acts which violate the tenant's protected order or led to the issuance of the protective order, including action for possession based upon complaints of noise, disturbances, or repeated presence of peace officers. So this means that it doesn't have to be solely based upon these acts, but it does have to be substantially based upon this. Are there any questions about the difference between those and what that means? Okay, great. So what rights does a protected tenant have? They can install a new lock at their expense by rekeying the lock, replacing the entire locking mechanism, and provide a key to the new lock to the landlord upon request. So if a tenant comes to you, they explain that I need a new lock. You as a landlord, you can request a couple things. a landlord can refuse to provide the named individual with a key to the new lock. So if it's myself and my partner, let's say my boyfriend, and both of us are named on the lease, my landlord can refuse to give my partner, my boyfriend, a key to the apartment complex, even though his name is on the lease. And it's because of this statute. So the named individual who has been excluded from the lease or rented property, and they still remain liable for rent. So let's say I change the lock, that doesn't happen, I have to move away. That individual, their name is on the lease, they're still liable for rent. So a protected individual who obtains valid protective order after entering into a lease or rental agreement, the lease or rental agreement may be terminated if the protected individual provides them with, do we have any ideas?
Copy of the protective order.
Yes. Okay, well, I'll go ahead and Alice, I see your question. I'm gonna go ahead and go through these real quick and then I will get back to you. I want you to make sure that I did see it. So they have to provide the landlord with a written notice of the termination to be effective on a date stated in the notice that's at least 30 days after the landlord's receipt of the notice. So just like with pretty much anything, I tell my landlord, I am moving away. Here's my notice to vacate. Typically it's 30 days after or before my move out date. And that's exactly the same here. My written notice of termination, I need to move away, has to be effective on a date that's at least 30 days after I hand that notice to my landlord. And the other thing, which I heard earlier, a copy of the valid protective order. So I need both things. I have to show that I'm a protected tenant because I have this valid protective order, which falls into those IPOs, EPOs, DVOs, and that I am providing that written notice to my landlord that is within that 30-day mark. Now, Alice asked, does the resident have to do the Violence Against Women Act form in order for us to recognize this? So this is the Violence Against Women Act is actually pertinent just to properties that are public housing, housing voucher, Section 8 housing. These statutes, these Kentucky statutes are applicable to all. So private and public housing have to abide by these state statutes. So that's a really great question. These, it's very similar. Like I said, the Violence Against Women Act is a little bit broader because the Violence Against Women Act actually doesn't have some of these requirements of like showing one of these, 4 or 5 protective orders. So it is a little bit broader. Whereas this Kentucky state statute requires these protective orders, it's a little bit more narrow in scope. But if you do have public housing or you take Section 8 housing, then yes, absolutely abide by the Violence Against Women Act. And if you're in Kentucky, also these state statutes. A lot of them probably do overlap, but I want to point out the differences between the two. So that's a great question. Thank you. So that was after I entered into the leasing agreement. What about if before the leasing agreement? A protected tenant who obtains a valid protective order before entering into a lease agreement or a rental agreement. Any ideas kind of what this looks like? This could be, go ahead.
I'm guessing they would just provide you a copy of that order so you would know that that person was not permitted to be on or near them at any point in time.
That's exactly right. And that actually goes into a little more detail. Now, if in this specific case, and Barbara, I see your question. I'll go ahead and answer it after we get through this. I just want to acknowledge that I do see it. So this is after entering into a lease agreement. This could be because maybe I have received noise violations. Maybe the landlord doesn't know exactly what's going on, but other neighbors have complained or indicated. Maybe this has happened on the grounds in the parking lot. If this is before entering into this lease or rental agreement, and I receive a valid protective order, exactly what I heard somebody say, you have to provide the landlord with that written notice. So if I've already paid the security deposit, but I haven't actually signed anything yet, I have to provide that written notice of termination, copy of the valid protective order, and this one is a little different. I also have to demonstrate a safety concern that arises from the execution of the lease. So we could be, in this case, I actually moved out of an apartment complex into your apartment complex now. However, my boyfriend found out where I lived, and I no longer feel safe in this unit anymore. Now he knows, somebody told him the address. I know I put down the security deposit, but I haven't actually signed the lease. I need to get out of here. I would now have to demonstrate and show that safety concern, as well as providing a copy of the protective order and providing written notice. Now, the question that I received was, many protective orders have limited timeframes on them, which is yes, that's correct. Does the protected tenant have to advise the landlord of the termination date of the order? So a copy of that protective order would include that termination date. Typically, they have it on there. On that protective order, it will say that this order expires on this date. So they will have that order. It is the tenant's responsibility to be providing that copy of that protective order. So if the order does expire, let's say it's a temporary interpersonal protective order, it expires, but then the tenant goes in submits a request for a domestic violence order, they would then have to bring that new copy of the valid protective order in order to be a protected tenant. I hope that answered your question. So here are some additional rights of tenants. The landlord may not give a tenant a negative credit entry or character reference based solely upon the early termination of the lease. So if I am terminating the lease, the landlord cannot then call the other, if I'm applying for a new unit, the landlord then cannot say, well, Miss Webb actually ended the lease pretty early and that was really annoying. I don't think she's a good tenant. It cannot be based upon the early termination of the lease. Now, what are some rights as a landlord? I know we talked a lot about the rights of the tenants, what they can do. They can end the lease early. They can get a new lock. What are some rights of landlords? Does anybody have any idea what that could look like, or maybe what that should look like? Give you a moment to brainstorm, maybe. Well, I'll give you a hint. So a named individual who's been, and again, a named individual is that person that is identified in that IPO, in that EPO, in that DVO. A named individual who has been excluded from the lease or rented property under this section remains liable for rent. So if two individuals are on the lease, is a issue of domestic violence, I provide that 30-day notice to my landlord. in the right time frame, I submit the protective order. What about the other individual? They're not, it's not a mutual DBO order. What about the other individual? They remain liable for rent. So you as a landlord can actually go after that named individual and request that rent. And even further than that, that named individual can actually be seen as somebody who interfered with that terminated lease. So the reason that that lease was terminated was because of this named individual, and therefore that named individual is responsible for all economic losses incurred by the landlord by that early termination. Something that we see a lot from our perspective is landlords will say, well, the lease terminated early. What about the cost of advertisement? I have to put up a new Zillow ad. I have to make sure that the property is upkept, potentially clean, conduct any repairs. All of that can actually be the responsibility of that named individual. So you can charge and submit those fees in that monetary compensation for that rent, early termination fees, repair damages, cost of advertisements, etc. So what else can a landlord do? A landlord can refuse access to the property by the named individual. So if the named individual comes to the property and they say, my name is on the lease, I should be able to access it. Can they access the property? Their name's on the lease. Are they allowed to?
Not if you have a copy of an emergency protective order preventing them from doing that.
Yes, exactly. So even though their name is on the lease, you can refuse access. You can also pursue all available legal remedies. So the termination of that lease agreement, the eviction of the named individual, you can evict that named individual and they can be responsible then for the eviction proceedings, the attorney's cost, the rent potentially. They can be responsible for all of that. And they won't have access to the property unless specified by court order. So something to keep in mind as a landlord, that you do have some rights. You can also, as I said, file action for damages against that named individual for that unpaid rent owed by not only the named individual, but damages resulting from that protective order. So now we'll go on to KRS 383.302, which prohibits inclusion of rental or lease agreement of the authority to terminate on the basis of the tenant's request for assistance in emergencies. So all this means, this is quite a short statute. All this means is that the landlord shall not include in a residential agreement for housing for a lease agreement a provision authorizing the landlord to terminate the agreement or impose a penalty. So not just terminate, but also imposing a penalty on the tenant for a request made by the tenant for assistance from peace officers or other assistance in response to emergencies. So this is what I was talking about before, that nuisance ordinance, that noise ordinance. That may be great. You may be thinking, well, that was great in Oregon, Pennsylvania, where you had those examples, Marissa. What about here in Kentucky? This is what Kentucky statutes indicates, that a landlord shall not include these kind of amendments, these kinds of provisions that indicate that may adversely impact and adversely harm victims of domestic violence. So if a landlord enforces a rental agreement or a lease containing a provision known by the landlord to be prohibited in this section, the tenant may recover actual damages sustained by the tenant, reasonable attorney fees, and all other costs incurred in bringing the action and punitive damages of no more than 2 months' rent. So this is why it is so important to know these laws, because if I'm a victim of domestic violence, I do everything that I am supposed to do. The landlord has this provision in their lease agreement, and then I'm evicted because of it. I can then go to court and recover these damages. Now, the reason that I have the whole list of cities that include the fairness ordinance is because you may have properties here in Lexington, you may have properties within the entire state of Kentucky. And as I stated before, victims of domestic violence is not a protected class under the Fair Housing Act, but sex and these other examples, race, ethnicity, these are members of a protected class. But even further than that, we know that domestic violence also happens in the LGBTQ community, just like how it happens in all walks of life. And so if you have an individual who is bringing forth an allegation of domestic violence, if it's a gay man and his partner, and you're thinking, well, that doesn't fall under sex because his partner's of the same sex as him, it can, and it does under these fairness ordinances. So that is something to keep in mind if you are in one of these counties or if you are outside of these counties. So before we get there, I would like for, if you can, shout it out. I know some people said their mic isn't working. If you can type it in. It's just some examples of prohibited activity from, gave you all some answers. Examples of discriminatory action, prohibited activity under the Fair Housing Act concerning domestic violence. Any examples? Well, then I will go ahead and let you all know examples of some discriminatory behavior. So evicting an individual after they filed an emergency protective order, not renting to women with a history of domestic violence, or even further, not renting to women at all, because you would say, well, I just think women are more likely to be a victim of domestic violence. I don't want that to happen here on my property, so I'm only renting to men. At that point, then you have, that is discriminatory behavior because of these stereotypes. In evicting an individual because of damage to the unit caused by the individual's abuser, that can be an example of a discriminatory action. Or evicting the individual for calling the police regarding their abuser. So these are some, I would say, the most common examples of discriminatory behavior that we see here at the commission, and that we often see landlords ask about. What about, especially the property? What if the individual is coming onto the property and is actively damaging the property? What can I do? Well, you can certainly prohibit that individual. Absolutely. You can also hold the individual for the cost of damages, but going so forth as evicting the individual because of the damages, after they have provided, again, after they provide that protective order, IPO, EPO, DVO, once they provided those kinds of protective orders to you, they then fall into the category of protected tenant. Do we have any questions about that?
Well, I guess they can be considered fall into that category even if they don't provide you a copy, correct?
So if they do not provide you with a copy of it, they are not a protected tenant. A protected tenant has to provide you with a copy of that documentation. So that's a great question. And once they provide you with a copy of that document, they do become a protected tenant though. So especially if you have especially if an individual has come to you and like tried to explain the situation, what I would do if I was a landlord is I would, explain, well, you do have some rights. However, I would encourage you to file one of these protective orders in order to assure that you will be able to potentially terminate the lease early without penalty. You will be able to change the locks, provide us a key. So I would inform them if I was a landlord, these are the steps that you should take in order to be considered a protected tenant.
Well, what I'm saying is, even though if a tenant files an emergency protective order and they don't give you a copy of it, you can still be found liable if you terminate that person.
Potentially. So depending on if,
Just might want to let people know that, because even if they're not provided a copy, they could be found to be liable.
yes. So it would have to be for example, they've like the police, and like a police incident is if you do have one of those, clauses, or not even a clause, if you do have one of these, you have a tenant, if I'm a tenant and the police is called continuously, however, if the police is being called continuously because of the domestic violence situation, at that point, then yes, I would have additional rights, or I would be able to file a complaint of discrimination within the Lexington Fair Housing Council, the HRC, the Kentucky Commission on Human Rights. I'd be able to file a complaint within any of these agencies because the situation was concerning domestic violence.
What would be the rights of the neighboring tenants? Would they be able to break their lease without cause because of the continued disturbance or fear of their safety because of the person that's being allowed to, this action is being allowed to continue to go on because of their protected class? I've had this, obviously in the past, and it becomes a very big concern for the neighbors and their safety, and also for what's protected in their lease, which is their right to quiet enjoyment. Where does that come into play?
Yeah, actually, great question. So concerning a neighbor, of course you can't indicate the situation that is happening next door, if how much they know or don't know. I'm not sure, but you can indicate, well, it's a domestic violence situation, so we're just gonna they're moving out, or whatever the case is. You wouldn't be able to do that. What I would actually encourage would be, because the neighbor, they do have as you said, they do have a right to the peaceful and quiet enjoyment of their livings, of the dwelling, of their unit. I'm personally strive to, well, can we move you somewhere else? I would encourage the tenant then, explain to them, if this is a domestic violence situation, I would encourage you to put these orders in place. That way we can take action as a property manager, as a leasing agent, because if the tenant is not taking, if the tenant has not taken action, the police come continuously, and it's later found out that it's domestic violence order, at that point, you as a landlord, once it's known to be a domestic violence order, you as a landlord, you as a property manager are then responsible. Before that, though, the neighboring tenant would not have a complaint under the Fair Housing Act. Unless the neighboring tenant would not have a complaint under the Fair Housing Act. So the best case scenario that I would strive for then in that instance would be to try to move the neighbor to another unit and then indicate to the tenant that is potentially experiencing domestic violence.
Well, you could do that, but what I was asking more about is most of the time, the neighboring tenant just says, I'm moving out and I'm breaking my lease because you've not upheld your part as far as providing us with quiet enjoyment. And if you try to move them to another unit, they're just going to say, well, I'm just going to move out instead. And if you do move them to another unit, then there's going to be expense on the landlord's part to prepare that unit, for, after they move out or the new unit that they're moving into or whatever. But there'll be some expense. So I'm just saying that it appears it would be that their rights become subordinate to the person with the domestic violence, because if they're fearing their safety, or if they can't sleep because of the continual disturbance, then they are probably going to vacate.
Yes, and I mean, that's a very hard situation to be in. I definitely hear your concerns of the neighboring tenants. I think you said like their rights then become subordinate to the individual who is a victim of domestic violence. Because what I can express to you would be that HUD provides in enforcement agencies like ours, because these individuals are a specific protected class under the Fair Housing Act. That is how we operate. That is why I personally probably wouldn't use the word like, their rights are subordinate. But that is why there are these special provisions in place, because they are a victim of domestic violence.
Well, obviously, you want them to be safe. You don't want someone to be harmed. That's true. But it would be nice if we have some guidance to say, okay, for what do we need to do for this other person? You know what I'm saying? Because they may be in a similar situation. They may fear for their safety as well. So we have to try to, when we are managing property with various tenants, we have to look out for the interest of all. And so it definitely becomes, as came up before, and it is an issue that has to be dealt with. So I just kind of wondered, what we were supposed to do. In most cases, we just have to let that person move. It's what usually happens. And so I just wondered if there was anything to alleviate, like if that person tries to come back and says you can't pursue me for this termination fee because you didn't provide me with quiet enjoyment, I guess that would be the case.
Well, what I would potentially also do is to record the neighbor's explanation of the reason why I want to terminate my lease is because of this situation. Because the named individual is responsible for these other additional costs, I personally don't see why the named individual would also not be responsible for the cost of other individuals breaking the lease because of this named individual's actions. So that potentially could be an avenue, at least, to help make up for that cost. I understand, of course, that the other cost is that we had a really good tenant and now they moved out. But the other potential costs that go with that tenant moving out could potentially be the responsibility of that named individual.
Meaning
as well.
the person, the abuser.
Yes. Yeah. Sorry. So that is what I would if I was in the situation, try to get them to move. They said, no, thank you. And you as a landlord are calculating, well, this is going to be this amount of cost because they feel like their personal safety is at stake. I would document that this individual is moving specifically because the abuser of the abuser and the abuser's actions, the abuser's threat to safety, and then move and then document that and list that individual, that abuser, as responsible for these additional costs as well. Did that hopefully answer your question? I know it's a very tough situation for pretty much all involved. You as the landlord, the victim of domestic violence, as well as the neighbors who are in a position where they also may feel unsafe. So, and you can also potentially encourage that neighbor to call the police as well, as long as there's not any action that is taking place. So even though the neighbor is calling the police about the abuser specifically is the one who is being listed as violating the lease for noise ordinance, etc., not the victim of domestic violence. Hopefully that helped to clarify. I hope it did. Are there any other questions? Well, my watch says that I'm right at 4:07. So a little bit over an hour. So I want to thank you for your time. If you have questions that or just some concerns, I will stay on here for a couple extra minutes. Just if you want to talk about afterwards, or feel free to shoot me an email. My email is right there, imweb@lexhumanrights.org. That's the best way to reach me, and hopefully I'll be able to answer your questions then. As I stated, I also provided that 2011, 2016 HUD guidance, as well as the 2 copies of the Kentucky statutes, the 300 and 302 as well. But if you need anything else, please don't hesitate to let me know. Well, thank you so much. Like I said, I'll be on here for a couple extra minutes. If you have any questions, I'll try to answer them then.
Thank you.
Thank you.
Marissa.